Honorable Justice Abida Ali Aroni. Two complaints were of particular concern to the board. These related to payments not made to clients while the judge was in private practice as an advocate. In the first case, the complainant alleges that the judge, while practicing as an advocate, received in June 1998 the sum of Kenya shillings 372,121 on behalf of the family's estate, and the complainant instructed the judge to invest the said sum in treasury bills. That was in 1998, but the judge failed to do so. That to date, the judge has failed to release to them the said sum of 372,121 paid in June 1998, which together with interests thereon, the complainant claims is Kenya shillings 38,751,886 as at the 30th of June 2012. The second case was by a complainant who alleges that in 1993, the judge, while in practice in partnership, represented her in a conveyance transaction. At the conclusion of the transaction, the partnership owed the complainant Kenya shillings 585,112.50. The judge admitted that the money was due and owing to the complainant, and stated that she had actually made payment to the complainant by cheque on 31st May 1993. Unfortunately, on the same day that she allegedly drew the cheque in favor of the complainant, the law firm's assets were frozen and handed over to the management of a receiver due to a partnership dispute that led to a dissolution. The judge was therefore unable to pay the complainant. In terms of Section 23 of the 6th Schedule to the Constitution and Section 13, 18, and 21 of the Vetting of Judges and Magistrates Act, the Board determines that the Honorable Justice Abida Ali Aroni is not suitable to continue serving as a judge. I now come to Honorable Justice Muga Apondi. The board felt it would not be appropriate for it to become enmeshed in considering their respective merits. There were, however, 4 complaints which the board thought deserved close consideration. The first related to a matter in which a farmer alleged that the judge had bent over backwards to grant an order that favored former President Moi. The issue in that case was whether the complainant's late father had transferred ownership of a piece of rural land to a school built on the land owned by the former president and named after him. The judge had in fact made comments which has presented the former president in good light. While the interviews with the judge were still pending, however, an appeal by the complainant had been heard in the Court of Appeal, which had overturned the decision made by the judge and found for complainant against the school. A perusal of the Court of Appeal judgment indicates that the appeal succeeded on legal grounds that had nothing to do with the alleged bias on the part of the judge. The board was accordingly of the view that no adverse inference should be drawn against the judge concerning the manner in which he had handled the litigation in that matter. The second matter that occupied special attention concerned a dispute over a proposed sale of a home in order to redeem a debt owing to a bank. After hearing arguments, the judge had issued a ruling in favor of one of the parties. Sometime thereafter, he had summoned counsel for the different parties to his chambers and announced that due to an inadvertent error on his part, he was setting aside his ruling and disqualifying himself from hearing the matter any further. The complaint alleged that the judge had refused to give any further reasons for taking this unusual step. He showered an inability to understand that the public would have specially high expectations. The judges would conduct themselves in an impeccable manner and refrain from deriving windfalls from what would be perceived as an unduly cozy relationship with public officials whom they might one day be called upon to hold to account. The board determines that the Honorable Justice Muga Apondi is not suitable to continue serving as a judge. In the case of Justice Ibrahim, the judge, presently a member of the Supreme Court, has invested heavily, both personally and professionally, in securing rights for minority groups, particularly the Somali community in Kenya. He has shown a highly developed commitment to social justice and admirable willingness to undertake pro bono activities and community service, even in the face of great difficulties. As a result of his opposition to aspects of the one-party regime, he was detained without trial in July 1990 and spent 1 month in solitary confinement in committee prison. By all accounts, he has shown himself to be a sensitive, warm, intelligent, and fair-minded judge with a wealth of experience and commitment to pursuing justice and serving his community and the nation. The board determines that the Honorable Justice Muhammad Ibrahim is suitable to continue serving as a judge. I now deal with the Honorable Justice Roslyn Nambuye. The matter came to the board after the board received an application to review a majority-based determination of unsuitability and decided to reopen the matter because of a patent error on the record. As the word re-vetting had not actually been used by the board, but rather by the media, it was agreed by all concerned that at the fresh interview, that this was a further hearing rather than a re-vetting. She observed, while in Kisumu, she had delivered over 200 judgments in 2011 and mentioned that the board should have looked at this amount of work, the output, and making sure that actually I was working, serving the nation, serving Kenyans. She was the sole judge sitting in Eldoret and serving Kitale. Now in Eldoret there are 3 judges, while in Kitale there are 2 judges, which brings the total to 5, and divisions have been established. The new civil procedure rules provide for pre-trial conferences, which allow parties to narrow down issues for trial, a tool not available when she was serving in Eldoret and Kitale. She informed the board that the Eldoret advocates even call her Mama because of her work and the judgment she had brought out from murder cases to land matters. When questioned on why the delays occurred, especially on Justice retired A.B. Shah's complaint that she was unable to say no when litigants appeared before her, she said that one cause of delay was the effect of transfers with no leave granted to write her judgments. Also, training and retraining for judges was deficient. They were simply appointed and thrown into the deep end. She has now learnt about her weaknesses. In the Court of Appeal, she has become more efficient. She is able to identify factual issues, principles of law applicable, get case law and authorities that are relevant, and produce a draft judgment very quickly. The board has come to the conclusion that despite the deficiencies pointed out in the original determination, she has the will and capacity to serve as a respected, hard-working and wise judge on the Court of Appeal. With only one dissent, the board has decided that she is suitable to remain in office. This decision is subject to the caveats mentioned above. The last one before us is Honorable Justice Mary Kasango. The judge graduated with a Bachelor of Laws degree from the University of Middlesex, London in 1978, was called to the bar at Lincoln's Inn in 1978, and is a barrister at law. In 1985, she was admitted as an advocate in Kenya. She was in private practice for 18 years before being appointed a judge of the High Court of Kenya in 2003. The judge has also lectured part-time at the Kenya School of Law since 1987. The complaints against the judge related mainly to the manner in which he handled matters in a court. She responded to the satisfaction of the board to all the complaints. The judge was of good temperament and demonstrated confidence and competence. Nothing untoward in respect of her conduct or integrity emerged from the interview. The judge came through as alert, focused, articulate, and clearly committed to the principles and the values of the new constitution. Members of the board were satisfied with her skills and competence and finds that she is suitable to remain in office.